they have not, their challenge to the executing court's order is in, let them proceed with that. Let the executing court look. I apologize. Because my solution is this. Because my solution is this.
If we keep this matter pending and direct the divisional court to decide the matter,
I have no difficulty. Yes, I think it will bring a quietus to everything. Your lordships may keep the matter pending, no difficulty.
this is one solution we are.
Because I have no difficulty.
We are not finalizing it.
I have no difficulty. Read that order of your lordships. I don't think, my learned friend's interpretation of that order is correct, because what your lordships did, I was not even present. Your lordships will see they were the only ones that came up on date. Because why? How should? There is no reason for it to go back to the tribunal.
Can I suggest?
Can I?
Yes, I have a small suggestion. No. Lordship, if a lordship just see the same chart, my friend, learned friend, have just referred at saying that it is an admitted. The amount of interest has been calculated only till 2019.
And we refer both of you to some mediation.
I was agreeable on the day one, or I would suggest. I would suggest. I would suggest something else. If
the most interest, both of you, we have now realized. You get great thrill in litigation. No intention to resolve. No intention.
Your lordships, MSME is party to these proceedings.
Can I give a suggestion? Let the executing court look at the correctness. There's a revision court. Look at the
MSME is a party, I thought.
And no, your lordship may keep the matter pending because we'll come back after 3 months.
Lordship, on MSME as a statutory council, they may come and clarify what they all want.
Arbitration award.
What
are you saying?
Please keep the matter pending. Let the civil revision court look into the executing court's order and come back to my lord.
What is your difficulty before the revision court?
I'll just indicate. I'll just indicate. The dispute arose in 2001. If your lordships may kindly appreciate.
Forget it.
No. 2010.
The award is to be executed, right?
Because whatever happens in that court, ultimately the matter will again travel to lordships.
So now, if this MSME clarifies,
yes,
that will not be subject to. Suppose it goes completely against what their interpretation is.
Yes.
That's what. You think they will garland them on their?
No. That's why we will be more satisfied if this entire award itself is interpreted by lordships, or that award. Your lordships may kindly appreciate.
We will not interpret them.
This dispute is going on for last around about 24 years, 25 years.
You have frustrated the very object of the arbitration.
And we have paid them. They have taken all the money. Because what I could have understood if I hadn't paid them.
Why they
the entire awarded. This is a case of a greedy litigant. This is a case of a greedy litigant having taken the money, now raising an interest bogey taking it. That's the difficulty.
The arbitration after 17 is an issue in law.
Yeah.
In the meanwhile, if the execution proceedings have taken place and you can interpret the award in your own way before the executing court, and then get it executed and
Ultimately,
interpreted.
this is the 10th round of litigation where
How will this cut it short? We don't understand.
because ultimately if something comes from your lordships, ultimately
You are all confused, I should say. We are not going to do anything like that. We are not sitting in panchayat. But if it can be referred to mediation, we're going to do it. Or
we are agreeable to that.
If the order, what can be done is that the interpretation of the award can be done by examining, not going behind the decree.
Natural.
Whatever it is, we will place it. before the-
That's why I'm just saying that just have a look at this delayed
Plus,
payment.
please issue
Just
that,
have a look
please
at-
issue that clarification
Just-
and let the civil revision court deal with it, plus. Plus, I will, plus, as an officer of the court,
How delayed payment act?
What is the relevance?
Because the award itself uses that word compounding, and compounding has been
Well,
basically
What is the number of that revision?
yes, plus, the number is,
Three
plus,
three numbers are.
that's right. Civil revision number 74 of 2021,
74 of 2021,
civil revision number 197 of 2021,
197 of 2021,
and civil revision 220 of 2021. Pending, Milords, before
220 of.
2021, pending before the Honorable High Court of Andhra.
Okay, all right. These revisions you will direct to be disposed of as early.
I'm,
In the meanwhile, so far as this judgment is concerned, we will ask the MSME also to pass an order on this within a period of 1 month. After that, it will be something.
very much
We dispose of both the, we dispose of the, leave granted. I think that's the. Leave granted, especially petition is against the judgment of the High Court of Andhra Pradesh in the petition number 34399 of 2018, dated 18/9/2020, by which the High Court had directed. Where is the operative portion, Mr. Diwan?
let's, paragraph 22.
Directed as follows. Okay. Respondent number 7 in the petition is the MSME council, correct?
That's right.
Is MSME council.
respondent
Where is
one.
it? This direction is to whom?
Direction.
First respondent.
First respondent.
Respondent 1, Milords.
Respondent one, your lordship.
That is the first respondent.
First respondent.
Okay, but the reason in petition and now setting aside the order passed by respondent number 7. First respondent in case number 7.
Yes, case number.
Direction to what did you say?
Respondent is having merit petition number, so is MSSC council.
Respondent number 1 is MSME. While affirming the directions of the High Court, we would further direct the MSME council to pass appropriate orders within from today. Simultaneous paragraph. Mr. Diwan submits that the revision petitions, numbers, revisions, civil revisions, no?
Lordship, please.
CRP.
CR.
Civil revision petition 74 of 2021, 197 of 2021, and 220 of 2021 are pending consideration before the High Court. We will also direct the High Court to dispose of the revision petition within a period of 6 weeks from today.
Very good.
High Court?
Let's, can I just make one?
Yes.
Let's, I mean, I'm assuming this because they can't now reopen their case before the MSM.
No.
It's an interpretation of the award.
Oh, we'll clarify
That's
that.
it. It's an interpretation of
That will be.
restrict.
Of course, we want to see.
That's right. They can't go behind what the award is.
Clarifying the award.
That's right.
First paragraph, directly so and so, to give the necessary clarification.
In respect to award. In respect to award.
Yes, sir. Then take your review of this. Doesn't seem to be any light in the end.
Look, in my respective syndicate, I mean, again, your lordships has passed the order, but the whole exercise of going back to MSME is likely to create more confusion because there is already a decree. There is already a decree with a crystallized amount. There's already a decree with a crystallized amount. Whether they are entitled. Because can I tell you what the difficulties? Let me be very frank.
Tell us, because
No, I won't take more than 30 seconds.
Where will I?
Look, the question is, today an officer looks at it and says that there's an order in our favor saying you've complied with the decree, you've gone in a civil revision. Now, how do I start giving him more money?
EPs are after EPs.
No, I agree.
On the next.
I'm deeply grateful.
We are disposing of this.
I'm obliged.
He is not to the. Yes.
May please.
Which item is this?
This is 57, Lord. I beg to appear for the petitioner.
Yes.
Lord, this was a suit for injunction which was dismissed by the learned trial court in the
You are
first.
the defendant.
And the defendant in the suit, Lord. In the first appeal, they apply for amendment of the plaint, Lord, to seek possession in the main plaint. Because the application is dismissed, the Honorable High Court in a 227 filed by them, Lord, has allowed the amendment application, allowing them to amend the plaint in a first appeal. This is, Lord, in nutshell what the case is, and we are up before your Lordship. Now, Lord, what has happened is this: prior to filing,
Two problems, no?
yes,
One is, on the one hand, law permits at any stage. On the other hand, the proviso will apply.
that's right. Now, these are the
Proviso says that after the hearing has commenced or issues, what does it say?
after the trial,
After the trial.
Commencement of trial.
You can't do it.
due diligence. I should not, in all fairness, say we'll read the proviso. If there is due diligence, court can still allow.
Even in appeal.
Yes.
So therefore, that proviso won't operate.
Proviso, my lord,
Due
that
diligence.
they have to
We'll
show
only have
due
to
diligence,
do
and I will read their application. Now, my lord, the test of due diligence, lordship will.
How does that operate? Because when the law says that once the trial begins, you can't do it.
And in a first appeal,
you can do it.
they can always file.
Due
They can,
diligence.
well, they can always file a fresh suit. Nobody is saying no. It's a possession if they want to see. So, my lord, therefore, I'm saying, now, my lord, in due diligence, there cannot be a better case than this. And I'll just explain to your lordships in a very short, my lord.
Only the relief clause has been amended, Your Honor.
That's all right. Now, my lord, before filing of even the injunction suit, they themselves apply to the revenue officers for demarcation of this land. And the report of the officer is that, my lords, I have encroached about 100 square yards.
By amending, what do they want to do?
They want to seek possession, my lords. Earlier, they only filed a suit for injunction. That was dismissed, my lords, as being not maintainable.
That becomes now a case of mandatory injunction.
Or possession, my lord.
That's the
Yes.
sir.
Mandatory.
Was he disposed during the pendency of the suit?
My lord, prior to the suit, that's what I'm saying.
How is it, sir?
Their own revenue officer says, my lords, pre-filing of the suit that I am in possession of the land. They annex that, my lords, with the suit, and the only prayer is permanent prohibitory injunction. I come in the written statement to say,
Give us facts and then
The plaintiff was a
complete your
co-sharer.
facts and.
yes, I'll complete the facts. Now, my lords, immediately before the filing of the suit, they applied to the revenue authorities, my lords, as I said. The revenue authorities, I have placed those documents. At page 68 and 72, my lords, say that I am in possession. But they admit that, my lords, I am in possession.
You're talking about the trial, is it?
The trial, my lords. So even before the filing of the suit, they first wanted to, my
It
lords,
was filed in which year?
my lords, the suit was filed in the year, my lords, 2015.
Prior to that, what happened?
3rd of August 2014, they applied to the revenue officers asking them to demarcate this land and to report, my lords, who is in possession. And that report is at page 72. And, my lords, it is mentioned at page 78 that your lordship's petitioner has encroached the land and is in illegal possession.
78 is the report, is it?
And, my lord, 78 is the conclusion.
Conclusion of the report.
The conclusion of the report. The report starts at 72. And it says that my client, has made encroachment and is in illegal possession.
Defendant in illegal possession.
Illegal possession, my lord. They filed that report with the suit. It is, my lord, exhibit P5 to P7. And their application for the same was exhibit P4.
P4 is what?
P4 was their application for demarcation, my lord. Exhibit P4. And exhibit P5 to exhibit P7 is the report of the retired Nayab Tehsildar.
Then what? Then they
Thus,
filed the suit.
Then they
What is
filed
the date of the report?
The date of the report, my lord, is 3rd of August 2014. My lord, 29th January 2015.
3rd of August 14. Okay.
Yes. So after about 4 months or so, my lord,
5 months suit filed.
suit filed, prayer is at page 82, decree of permanent injunction.
Page?
Page 82, my lord.
Permanent injunction.
Permanent prohibitory injunction is what they see.
Suit is rejected.
And so I must also say, my lords, my defense was I am a co-sharer since my ancestors' time. But during pendency of the suit, this specific 100 square yards I have also purchased from one of the co-sharers. This was my defense. I annexed the sale deed. Now, despite having taken this defense, the suit is still not amended, my lords. The suit is proceeded with. And after, my lords, the complete trial, the learned trial court, my lords, dismisses the suit by holding that since they have themselves not admitted that I had come in possession even prior to the institution of the suit.
And he has not asked for possession.
Nothing at all.
The suit is not maintained.
Not maintainable.
Not maintainable, is that?
It has had to be not maintainable because injunction cannot be given for which I have already done something.
How can it be correct? And the suit.
And, my lords, the complete trial is
Now
held.
in appeal,
Now in appeal, my lords, they first file an application to amend the plaint. Then they file a second application to amend the amendment application.
to fill in the lacuna.
To fill in the lacuna. Now, my lords, due diligence kicks in here that when in your own document.
No, first they filed an application for amending the prayer in the.
And then they file an application to amend that application. So there were two applications, my lords. Page 168 is the first application. And page 173 is
The application was for amending the.
for amending the prayer in the plaint, but in first appeal.
That's not.
Yes,
Second one is?
Second one is to amend the application itself.
No, I don't think so. Just see.
Lord, what they do is
Application itself means the.
amendment application itself.
No, I think amended grounds, I think. Seeking
Lord,
amended grounds.
amended grounds in the amendment application.
Whatever.
Please see
Both are one
168.
and the same.
Yes.
So trial court dismissed it.
And 168, 169, when your lordship sees the application, the 617 proviso, everything is out of the stadium. No due diligence, nothing. Just come as a matter of
What
fact.
did the High Court allow it?
The Honorable High Court says that they just want to amend the prayer clause.
Yes, tell us, sir.
Yeah. No, when we filed the suit, At that time, I was a co-sharer in this land, and the opposite party, the defendants, were trespassers. Just 3 months after the filing of the suit, the opposite party purchased a share in the suit land. At that time, they became co-sharers in the suit land. So when the suit was filed, I claimed a decree of injunction only, Your Honor.
You didn't understand.
Injunction
At the
only,
time
Your Honor.
when you filed the suit, you stood in the position of a co-sharer
As a co-sharer.
when you filed the suit.
When I filed the suit, I was a co-sharer, but the opposite party, the defendant,
He
was a
represented
trespasser.
by you.
Yes,
Was it?
trespasser.
So they were in possession.
They were in
Why have you
possession.
not asked for possession?
This is because the opposite party became a co-sharer in the land
He
3
was
months.
already a co-sharer by the time you filed the
Not
suit.
already a co-sharer. In the revenue record, which is exhibited as Exhibit P2, and which has been filed as an additional document before Milords, shows that the opposite party, the present appellants, were not recorded in the ownership column at all. Only my name figured in the ownership column along with other co-sharers.
Then he is a trespasser.
Yes, sir.
You only asked for injunction
Injunction. Correct.
injunction against him.
Correct, Your Honor. Because I was an owner, but they were not owners.
Right.
So the injunction which
When did he become a co-sharer?
I'll clarify it. Your Honor.
3 months
Two
after
points.
filing of the
After the
suit.
filing.
There are 2 points involved here. One is the suit land. The suit land is about 1200 square yards. These people were in unauthorized possession of 100 square yards only. So for the remaining 1100 square yards, I could pray for a decree of permanent injunction. Now, this is one point. Second point is, 3 months after the filing of the suit,
They became the co-owner.
they became co-owners in this land. So how, if I want to amend the plaint to claim a decree of possession,
So
as
they
they
continued in that status till the disposal of the suit.
No,
And during the first appeal stage that the position has changed.
there's another point involved here, which I would claim which I beg your opportunity to clarify.
No, please go ahead. We are not in.
So the point involved here is, Your Honor, that when they became co-sharers in the land, if till that point, till that time, within this period of 3 months, I could have filed an application for amendment to claim possession also, since they were in authorized possession. But when they became co-sharers in the land, then the law regarding co-sharers came into effect,
You
and
could not have filed for possession.
we all became in deemed possession of the land. So if I prayed for an exclusive relief for possession,
So initially, you should have filed a suit for possession and injunction.
Injunction, both.
And once they became co-sharer, you could have deleted the prayer for possession.
I think you're absolutely right. Now,
You should have done that.
after allowing this particular point, Your Honor, that on the date of filing the suit, I should have filed for the relief of possession. I now argue the second point is that Order 6, Rule 17 is available to me as a litigant to amend the plaint. Now, before I could amend the plaint, they became co-sharers in the land. So therefore, for me to amend the plaint was no longer possible. So therefore, there can be no due diligence.
If they have become the co-owners, then why are you amending the plaint and asking for possession?
That's
Co-owners have equal rights
correct.
of possession.
Your Honor, absolutely correct.
So this prayer is totally redundant.
But the reason for that, my lord, is the reason for this application before the first appellate court was that the trial court.
In your applications, what did you say in your applications?
In my application, I first of all prayed for relief of possession. Then I filed a second application praying that the earlier relief of possession should be substituted with a relief of joint possession, because the parties are co-sharers. This was the extent to which I wanted to amend the first amendment application to claim joint possession instead of simple possession. Now, my lord, we'll see that small point.
And he became a co-sharer.
Yes, my
He
lord.
is no more a trespasser.
He's no more a trespasser.
And he is no more a trespasser.
You can't
To pray
seek
for
injunction
injunction.
against him.
I can, because the relief clause, the cause of action says that he's interfering in my possession.
No, everyone has the right on every inch of the land which is
Unless you
jointly
say that he
possessed
is
by
not
them.
letting me enter
For
into
that, I have a judgment here, Honorable Court, which says this is Lakshmi Path versus Nityanand.
in your plane.
Kindly see in this judgment, para 25. Para 25 reads as follows. Third line, the law as to co-sharers is well settled, where any property is held by several co-owners. Each co-owner has interest in every inch of common property, but his interest is qualified and limited by similar interest of other co-owners. One co-owner cannot take exclusive possession of the property, nor commit an act of waste, oust, or illegitimate use. If he does so, he may be restrained by an injunction.
All the way.
So
Not
this,
denying that. You are right that it is there. But then, so the nature is changed.
no, nature is not changed.
Initially, you.
Allow me to clarify further. What happened
We'll
was,
continue.
what happened was,
ये partner देगा, ये एक मैटर partner बना ले, Monday ले लेंगे. So Monday will continue on Monday. Other matters will give whenever the slot available for a 2 o'clock matter.
Yes. In
That
fact,
will be mentioned. It will be
we were
sometime
going
in
to,
August.
I understand, my lord. In fact, can it be after that break in August? Item 59, my lord. My friend is on the other
You are
side.
expecting us to sit during the break.
No, my lord. I'm saying on this side of the break, the other side of the break.
After the 23rd of August.
After 15.
After, that's right, after that.
Some date will be fixed, and if it is a 2 o'clock matter, date will be fixed, and will be, these proceedings will indicate which date it will be.
Something, we'll be obliged for that towards the end of August or something.
Item 58, Lordship, item 58, which is the next item. I am appearing for the Public Service Commission. It's a state's appeal. But the actual person who is getting affected, he is not appearing in this.
It's somebody there.
Those,
So what? Promotion of the
yes,
retired.
yes. So he's the actual person affected.
What do you want? Let it come.
Lordship.
If service is complete, then we will. allow.
Yes, service is
We're
complete.
deeply obliged.